Okay, everyone, this week there were new filings in Don Lemon's criminal case, most of them complaints about the government allegedly not complying with discovery obligations, and as a result, the defendants say they were irreparably harmed. Not the case, because unless we're talking about physical evidence, it won't decompose, it won't degrade, it won't lose its forensic value. Now, Don Lemon and his co-defendants will obtain access to it eventually after the government has itself gone through it and cataloged it. What are we talking about here? Documents and videos. Now, that's the type of evidence there is in this case. If the defense genuinely is mystified why the court has been extending the discovery deadlines and all other deadlines in the schedule as a result, that could be a reason. Now, this week, Don Lemon's attorneys asserted a new argument for speeding up the discovery process, but did it in a way that the judge didn't like. So, this is what happened this week. Now, the activist-defendants filed what I regard to be a non-controversial request to extend the deadline for filing pretrial motions by a month. The reason they give is the government has recently handed over thousands and thousands of pages of discovery material, and the activist defendants need time to go through it before filing motions. Now, is it credible to say that the government has been lollygagging, dilly-dallying, dawdling on purpose? No, it's not credible. Don Lemon's attorneys don't argue that, but they say that the delay is causing reputational harm to the journalist-defendants, and they want to get on with it. So, they ask for a separate pretrial schedule, which provides for different filing deadlines for the journalist defendants. Then, right on cue, another one of the journalist defendants, Shane Bowman, files a motion asking for a separate pretrial schedule as well, then says he will seek severance at the trial. Boom, he wants a separate trial all to himself. Now, the judge denied the journalist defendants' requests for a separate pretrial schedule. Now, it didn't say why, but in my view, it's because it would hugely complicate case management. And Don Lemon's attorneys filed their request in a way that makes him look bad. Lemon's attorneys say that the new discovery, the new tranche of discovery, thousands and thousands of pages just produced by the government, contain almost nothing of interest to the journalist defendants. It's not relevant to us, Don Lemon's attorneys say, so we don't need a delay in the schedule. Give us a separate pretrial schedule. It's a diva request, okay? The court system isn't CNN. Lemon doesn't get his own trailer. And beyond the diva request, it's strategy. They want a separate trial just for the journalists. Although the actions of each defendant are intertwined. It's an alleged conspiracy. That's why they were indicted together. Now, generally speaking, the defense often will assert in conspiracy cases that there's a risk of guilt by association and not by the evidence. But the problem is that conspiracy law is a law of vicarious liability. Joining a conspiracy means that the actions and crimes committed by one co-conspirator are imputed to all other co-conspirators. That's literally the law of conspiracy. So this brings us to co-defendant Georgia Fort. A flurry of activity this week from her attorneys who succeeded in convincing the judge to look at the grand jury transcripts for references to Georgia Fort and to Michael Walker Butte, who's the camera operator for Don Lemon and a co-defendant as well. Now, the judge will look at the grand jury materials in camera, meaning in chambers without disclosure to the parties. Now, what the judge will be looking for are statements by the government to the grand jury asserting that Georgia Fort was chanting anti-ICE slogans, blocking the escape of the churchgoers, blocking a van filled with churchgoers by standing in front of it, etc. Now, if the judge finds those types of statements, Georgia Fort and Michael Walker Butte say that they could seek sanctions. But in my view, dismissal eventually would not be warranted because of conspiracy law. Next issue. Small issue could become big later on. Now, it caught my attention. One of the co-defendants, Thomas Matthew Tier, filed a slew of documents this week. I won't even deal with them until the government files a response. But one thing his attorneys say is the government is allegedly investigating the sources of his legal defense funding. Now, I believe that that's relevant. Often in connection with an indictment, the government will seek forfeiture of assets if there's probable cause to believe the assets are criminal proceeds. Or maybe were used to facilitate illegality, or maybe were involved in money laundering, drug trafficking, fraud of those types. Now, co-defendant Thomas Matthew Tier is represented by a high-profile law firm. Could be a pro bono representation, but maybe not. Apparently, the government is investigating. Next issue, and I'll just conclude with this. Co-defendant Ian Davis Austin, the only co-defendant who was arrested for anti-ICE protest activity after being indicted for the city's church invasion. He's being punished for it now. The court just imposed a raft of restrictive release conditions. Here's the list. Now, the judge signed the list. He crossed out one of the conditions, but the other conditions are in effect. Okay, and so the government had requested a hearing on Ian Davis Austin after he was arrested twice, and he's on video at that New Jersey anti-ICE protest saying, "We are effing willing to die out here." Now, 2 days after the court granted the government's request for more restrictive release conditions, the U.S. attorney filed this exhibit list. Okay, the exhibits weren't marked and offered into evidence, so these columns are blank, which indicates there was no evidentiary hearing, but this list shows us the U.S. attorney went to that hearing prepared to throw down, okay? When a defense attorney asks for a hearing, it's usually a motion hearing, okay? They want to go before the judge and speak to the judge, but when the government asks for a hearing, they're prepared to throw down. And so I say it's not credible to assert that the government is trying to delay the trial of the case on purpose. Not credible. And the law of conspiracy, which we broke down in this video, doesn't give us any indication that the government wouldn't be ready either. And for Ian Davis Austin, this exhibit list seems to indicate if he violates his release conditions again, the government will seek to detain him until trial. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.